minor's initials versus her full name?
Yes, please use the minor's initials.
Okay.
And do we have a translator here?
We do, Your Honor.
Good morning, Your Honor. Olga Stecker here, sir.
Do you want to call your first witness?
Yes, Your Honor. We'd like to call Jose Contreras, please.
All right. First, I'm going to swear in the translator. Do you swear or affirm that you'll faithfully translate the matters in this case from English to Spanish and Spanish to English to the best of your ability, so help you God?
Yes, Your Honor, I do.
All right. If we could have the witness go ahead and raise his right hand. I think he just left the screen.
Sí, el señor Contreras. Buenos días, señor. Por favor, levante su mano derecha y vamos a necesitar que activen el micrófono.
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Usted jura y afirma que el testimonio que está a punto de dar será la verdad, toda la verdad y nada más que la verdad. Señor, ¿lo jura?
Sí.
Yes. Gracias. Puede bajar su mano. Gracias.
All right, you may proceed.
Could you state your full name for the record, please?
Por favor, señor, diga usted su nombre completo para el acta.
Mi nombre es José Igmar Contreras.
And
José Igmar Contreras.
sorry, I forgot you have to translate. Could you describe how you're related to the minor child AR in this lawsuit?
Señor, ¿me podría usted decir qué es usted? ¿Cómo es usted familiar del menor involucrado en esta causa que lleva por iniciales AR? ¿Qué es usted de AR?
AR o Ángela. Se refiere a Angelita.
Sí, AR.
El papá.
Preferimos que no diga el nombre del menor, por favor.
Oh, ok.
¿Qué es usted de ella?
Soy el papá.
I am her father.
Okay, and she was involved in a motor vehicle accident on September 18th of 2017, correct?
Ella estuvo involucrada en un accidente automovilístico el 18 de septiembre del 2017. ¿Eso es correcto?
Sí, es correcto.
Yes, that is correct.
Okay, and we filed a lawsuit, both for yourself and as next friend of AR, correct?
Entablamos una demanda por los dos, por usted y también por su hija AR, ¿verdad?
Sí.
Yes.
And that lawsuit was against the defendant, Melchor Segura.
Y esa demanda fue en contra del demandado ahora, Melchor Segura.
Sí.
Yes.
Okay. Now, we've been able to negotiate a settlement with the insurance company in this case, correct?
Nosotros hemos podido ya negociar una liquidación, un acuerdo con la compañía de seguros, ¿cierto?
Sí.
Yes.
And you had a chance to meet with the guardian ad litem to go over that settlement agreement and the release, correct?
Usted ha tenido ya la oportunidad, señor, de reunirse con el tutor, con el guardián, cuidando los intereses del menor para que hablaran de este acuerdo. ¿Eso es cierto?
Es cierto.
That's true.
Okay. Let's walk through how the money is to be distributed. First of all, we have a grand total of $5,000, correct?
Antes que nada, bueno, vamos a hablar de cómo va a ser la distribución de este monto. Antes que nada, son $5,000, ¿verdad?
Sí.
Yes.
Okay, and out of that $5,000, we're going to pay $487.50 to the MDN Accident Injury Pain Centers for services they provided to AR, correct?
Vamos a pagar de esos $5,000, 487,57 centavos a un centro de dolor, Accident and Injury, MDM, por tratamiento que le dieron a la menor. ¿Eso es cierto?
Es cierto.
That's true.
And we'll be paying Dr. Bruce Cheatham $75 for the services he provided, correct?
Y le vamos a pagar al médico Bruce Cheatham $75 por los servicios que él le hizo también, ¿cierto?
Cierto.
True.
And we're going to pay $1,500 to the Accident Centers of Texas for the services they provided, correct?
Y también le vamos a pagar $1,500 al Accident Centers of Texas por los servicios que ellos dieron también, ¿cierto?
Cierto, sí.
True.
And we're going to pay $100 to North Texas X-Ray Services for the medical care they provided to AR, correct?
También $100 se le va a pagar a North Texas X-Ray Services por los servicios que ellos prestaron, ¿verdad?
¿Verdad?
Yes, true.
Okay, and you understand that our attorney's fees on this case are $1,300, correct?
Usted entiende que los honorarios de los abogados en este caso son $1,300, ¿verdad?
Sí.
Yes.
And finally, that leaves $1,537.50 that will be paid into the registry of the court for AR. You understand that?
Y finalmente va a depositarse $1,537.50 en el registro, en la cuenta del tribunal para la señorita, para AR. ¿Cierto?
Cierto.
True.
Okay, and you realize that this is all of the money that you will receive from this lawsuit, correct?
Señor, usted se da cuenta que este es todo el dinero que ustedes van a recibir por esta demanda, ¿verdad?
Sí.
Yes.
And you understand that because you've entered into a settlement agreement, you cannot sue these people again for the same accident.
Usted entiende, señor, que como usted se está comprometiendo en un acuerdo, usted no va a poder demandar a las mismas entidades, las mismas personas por este accidente. Entiende que no va a poder hacer eso más.
Sí.
Yes.
And you understand that because we've entered into a settlement agreement, there will be no jury trial in this case.
También usted entiende, señor, que como están llegando a un acuerdo con esta otra parte, con la parte demandada, eso quiere decir que no va a haber un juicio por medio de un jurado. ¿Usted entiende eso? No
Sí.
habrá juicio. Yes.
And you understand a jury could have awarded more, they could have awarded less, or they could have awarded nothing whatsoever.
Usted entiende, señor, que un jurado pudo también haberle otorgado a ustedes más dinero, menos dinero o quizá nada absolutamente. ¿Usted entiende eso?
Sí.
Yes.
Okay, and you understand that the $1,537.50 is being paid into the court's registry, and that without a subsequent petition to this court and some kind of emergency, you will not be able to remove the money from the registry until AR reaches 18.
Señor, usted entiende que el dinero que se está depositando en el registro del tribunal, $1,537.50, sin una petición firmada y autorizada por el tribunal o sin una emergencia, este dinero se va a quedar en el registro del tribunal hasta que AR cumpla la mayoría de edad de 18 años. Usted entiende que ese dinero se queda ahí hasta los 18.
Yo quisiera hacer una pregunta.
I'd like to ask a question.
Certainly.
Seguro, dígame.
Como ella, tiene un bebé, no sé cómo ella pasa ante la ley, como si es mayor de edad o todavía sigue siendo menor de edad ella.
Ok, permítame. Well, you see, since she does have a baby, I don't know how she appears or how she would be according to the law, if she would be considered an adult because she has a baby or if she's still a minor.
Until AR reaches the age of 18, the only way that she's going to be able to take money out of the court is if she files a petition with this court and can prove some sort of emergency.
Señor, Otra vez, le repito lo mismo, hasta que AR cumpla la mayoría de edad de 18 años, no hay otra manera de que se pueda entregar ese dinero a AR, a menos de que haya una emergencia que se presente y que se haga una petición con el tribunal y que el tribunal apruebe esa petición. Es la única manera. De otra manera, ese dinero se queda en el registro del tribunal hasta la edad de 18 años de AR.
Do you understand what I've just told you, Mr. Contreras?
¿Entiende, señor Contreras, lo que le acaba de decir el licenciado, el
Sí.
abogado? Yes.
Okay. Do you believe this settlement is in the best interest of AR?
Señor, ¿cree usted que esta propuesta de liquidación, este acuerdo, es en el mejor interés de AR? Señor, siente
Sí.
usted. Gracias. Yes.
Okay. I have no further questions at this time. Thank you, Mr. Contreras.
Un momento, señor Contreras, no tengo más preguntas. Permítame un segundo.
I think you're muted, Judge.
Do you have any questions, Mr. Montrose?
No questions, Your Honor.
Mrs. Savas, do you have any questions?
Yes, I do, Your Honor, briefly.
Ok, brevemente, señor.
Mr. Contreras, you and I had an opportunity to meet before today, correct?
Señor Contreras, usted y la señorita tuvieron la oportunidad de reunirse antes del día de hoy, eso es cierto.
Cierto.
True.
And you understand that I'm the guardian ad litem and I've been appointed to represent the interests of AR, correct?
Usted entiende, señor, que la señorita que está hablando es tutor del menor. Eso quiere decir que es la abogada guardián que cuida los intereses de su hija, del menor. ¿Usted entiende eso?
Sí.
Yes.
Now, in our meeting, we had an opportunity to talk about the accident, AR's injuries, and how she's doing today, among other things, correct?
Durante nuestra reunión tuvimos nosotros la oportunidad de hablar del accidente, de AR, de sus lesiones, de cómo se encuentra ella ahora, el día de hoy, aparte de otras cosas, ¿verdad?
Sí.
Yes.
We also went over the settlement disbursement, correct?
También nosotros hablamos y conversamos sobre cómo se estaba distribuyendo el monto, ¿correcto?
Correcto, sí.
Correct, yes.
And we discussed that the $1,537.50 would be going into the registry of the court for the benefit and use of AR when she turns 18.
Hablamos, señor, que los 1,537,50 centavos se iba a quedar en el registro del tribunal hasta que AR cumpliera los 18 años. Hablamos de eso, ¿cierto?
Cierto.
True.
And you understand that those are her funds, correct?
Usted también entiende, señor, que ese monto, esa cantidad es de ella, ¿correcto?
Correcto.
Correct.
And you understand that she will have access to those funds when she turns 18.
Usted también entiende que el acceso a ese monto, a esos fondos, va a estar ahí para ella cuando cumpla 18 años.
Así es.
That's right.
Okay, Mr. Contreras, and are you asking the court to approve the settlement because you believe it's in the best interest of AR?
Muy bien, señor Contreras. ¿Está usted pidiéndole al tribunal, al honorable juez, que apruebe esta propuesta de liquidación, este acuerdo, porque usted siente que es en el mejor interés de AR? ¿Está usted pidiéndole que lo apruebe?
Sí.
Yes.
No further questions, Your Honor. I pass the witness.
Mr. Contreras, do you have any questions for me?
Señor Contreras, ¿tiene usted alguna pregunta para el señor juez?
Pues que ella cuando cumpla los 18 años dice que ella es la que tiene acceso a ella, o sea, a ese dinero, a la corte o a dónde ella puede hacer el reclamo de ese dinero.
Well, they were just telling me that she will have access to that money when she turns 18. So will she be going to the courthouse or where will she go to claim her money?
Mrs. Savas, did you talk to them about that?
So we briefly discussed it, but I'm happy to go over it at length after the hearing and talk about the registry form as well as the how they can access the funds.
You'll need to go to the trust office of the Dallas County, and Mrs. Savis will explain to you how to do that, okay?
Señor, hay una oficina, le está contestando su pregunta al señor juez. Hay una oficina en el condado de Dallas donde van a poder ir a retirar su dinero. La señorita Seves se va a reunir con ustedes después de esta audiencia o en unos días más adelante, no hay tanta prisa, para que ella le explique exactamente a dónde tienen que ir a reclamar el dinero. No se preocupe, ella le va a explicar.
Did you have any other questions?
¿Alguna otra pregunta, señor, aparte de eso?
No.
No.
And is this your daughter here on the screen with us?
Señor, con usted aquí en la pantalla, ¿es su hija ella?
Sí.
Yes.
And it's weird calling you AR, but AR, do you have any questions?
¿Tú tienes
No.
una pregunta para él? ¿Para el juez?
No.
Do you understand this is your money when you turn 18? And if you have an emergency between now and when you turn 18, you can ask the court for an early disbursement, but it would need to be some type of emergency. Does that make sense?
Yes.
Okay. All right. Well, thank you so much. Is there a recommendation from the guardian ad litem?
Yes, Judge. After reviewing the medical bills, medical records, speaking to plaintiff counsel's office at length about the disbursement, I do believe that the settlement offer of $5,000 that has been extended to AR in this matter is reasonable to compensate her for her injuries related to this accident. Therefore, I would request that the court approve the settlement at this time because it is in her best interest.
Court will approve the settlement as requested by the guardian ad litem. Has there been discussion about the amount of the guardian ad litem fees?
I did consult with defense counsel's office and they were agreeable to my fees, but Mr. Montrose can confirm to the court.
Yes, sir. We agreed to the fee. It looks like it's on page 6 of her report, so we think that's reasonable.
And if I, just to make it clear on the record, let me look that up real quick. It's $1,520. Is that accurate?
Yes, Your
Yes.
Honor.
All right. Mrs. Savis, thank you so much for your service. Mr. Contreras, and I think her name is Angela, I'm just guessing, but your daughter, AR, we wish you the very best of luck and a happy holiday season. And Mr. Montrose, Mr. Kingray, I'm glad you guys worked all this out. And you guys have a happy holidays and you are excused. I'll go ahead and sign the order today. We'll get it scanned, sent to the clerks, and hopefully it'll get entered today, hopefully.
Thank you very much, Your Honor.
We have
Thank you.
the proposed final judgment and then the proposed order approving the guardian ad litem fees, Your Honor.
I will sign both. Thank you for submitting both of those.
Thank you, Judge.
Great to see you.
Nice to see you as well. Take care.
All right, guys. Thank you. Have a good day.
Bye.
Hey, Nancy. Hey, Tony. How are you guys doing? Rhonda, I just wanted to remind you, and if you could talk to Rose about this, that I'll probably be coming in the office sometime on Saturday to sign all those orders. So just try to collect as many as possible. And the Monday hearing docket looks like it's really short, Tony and Nancy.
Okay.
I think we'll be done by, it looks like 10:30 unless something changes. So, let's see. Yeah, and Rhonda said that was good.
You're on YouTube. Judge. You're on YouTube.
Oops, sorry. Oh, well, let me just let in the next case then. And Josh, are you there?
Yes, sir, I am. I'm getting a I'm getting a COVID test today. I apologize that my camera's off. I'm just not feeling
It's okay.
too well today.
Hello, Mr. Paz, are you there? I think you're muted, sir.
Yes, Your Honor, I'm here.
Okay. Do we expect the opposing counsel to be here for the hearing?
No, Your Honor, we submitted to the court by e-file an agreed order on the 15th of December.
Okay, let me take a look for that. I don't think I saw that when I looked at this last, but let me see if I have it now. There was an issue on service, I guess, for this.
That is correct, Your Honor.
So you don't think Mr. Reed will be here today?
I don't believe so. I haven't.
Let me just check. You said you submitted on the 15th. There we go. Let me look at it. I'm going to share screen. Oh, let's see. Let me just check and see if there's anything we need to hear from the opposing counsel on. I'm going to share screen the order. I think this is it. Okay, is this the order you were talking about?
Yes, Your Honor.
So I guess the main question is, when do you want us to set this for trial?
There's an ongoing eviction case related to this case, Your Honor. So as quickly as possible, because this case needs to be resolved before we can proceed with the eviction. So I'm not sure when you're setting cases, but sometime in the summer probably would be sufficient.
Is it jury or non-jury?
I have not requested a jury, and I don't believe the plaintiffs requested a jury, so it's non-jury at this time.
So, and we're gonna, yeah, Rhonda, go ahead and call opposing counsel, because I don't want to make this decision without him. We just got voicemail. But let me kind of discuss with you about that. So for non-jury trials, we can try those pretty quickly. We are doing everything possible to try to get those cleared out. And so assuming that there isn't a jury fee that gets paid, then we can get that tried, as soon as you want, as both sides agree. I don't usually do it like in a month or two. If you guys wanted to, we could do it that quick if both sides agreed. If you want a jury, if you're willing to agree to a remote jury trial, we can probably get you in by May. But if you're not willing to agree to a remote jury trial, it would probably be sometime in 2022.
Okay.
Just given our dockets. And I'm not trying to give you a hard time. We're really backed up, as you might imagine.
Yes. And I'm emailing opposing counsel right now, seeing if he's available. I know the hearing set at 9:30, so he may not have checked in if he was going to appear.
Okay.
So is the courthouse scheduled to open up at the beginning of the year, or is it still closed, Your Honor?
What do you mean?
I know some courts weren't having in-person hearings and doing everything via Zoom. Is that a court-by-court decision, or is that a county-wide decision?
So the Texas Supreme Court has issued a number of emergency orders. This may be him. His name Anthony.
Yes.
And so the Office of Court Administration, Texas Supreme Court, are both strongly encourage us not to have in-person hearings unless absolutely necessary. We adopted a reopening plan for Dallas County back in July, I think. We've been ordered to, not just we, but all the counties have been ordered to redo that given the state of the pandemic. So my personal policy is that I don't hold in-person hearings unless requested by both parties and a determination that I feel like I need to. So since the pandemic started, I've only had, Nancy, how many? 3 hearings, maybe 2 hearings that were in person, or at least partially in person? 3, I think, maybe.
Good morning.
Yeah. Hello, Mr. Reed. Is that you?
Yes, Your Honor. Good morning.
Good morning. So we got the agreed order on the motion for new trial, and we were just kind of talking about when we wanted to set this for trial. And so we wanted to make sure we had kind of your opinion on this. Do you know if the other side has said that they were okay with the non-jury? Have you thought about whether or not you want to do a jury or non-jury on this?
I haven't really talked to my client about it, but I don't have an issue with the non-jury trial.
Yeah, a lot of these partition cases are non-jury. So what I was telling him in terms of scheduling is, as you can guess, we are much more flexible on setting these for non-jury than we are for jury. We haven't been able to try a jury trial for the last 9 months. And so if you're willing to agree to a remote jury trial, then we can get you in quicker. If you're wanting a live jury trial, it's going to take quite a bit longer, probably 2022 or later. And so I'm happy to set this on the docket whenever you guys would like, but just understand if you're wanting an in-person jury trial, it would probably be sometime in 2022.
Yeah, I think we're more inclined to do a non-jury trial, and I also know, and I've spoken with opposing counsel briefly when we first started this thing. I think my client is willing to get a quick mediation in the case done. So I mean, we may not even get there.
What? So when would you like to set it for trial? What would be a good time? May, he suggested, I think April or May. Is that what you said, Mr. Paz?
I suggest sometime in the summer, Your Honor.
Oh, summer. I apologize. Sometime in the summer. How do you feel?
Yeah,
How do you feel?
A Midsummer's Night Dream is fine with me.
Okay. How about sometime in July? Would that work okay?
Yeah, sure. That works for us.
All right, Rhonda, set this in July. And then do you guys want to pick a mediator?
I think we can reach an agreement, Anthony, on a mediator, don't you?
Yes, I do.
Okay. If you guys need help on that, we can do that now. But if you guys want to do that yourself, we may have already sent you a court-appointed mediator, but if you guys want to agree to someone else, I will almost always agree to that. So anything else we need to talk about?
Just as far as the agreed order, Your Honor, it just needs to be signed by January 11th in order to be effective. So I'm not sure.
I'm going to sign it today, and I'll go ahead and get that sent into the court today. But thank you for letting me know about the deadline. I'll make sure that we get that scanned hopefully today. All right. Anything else we need to chat about, guys?
No, Your Honor.
I don't have anything.
Okay. Oh, wait a minute. I just got a text from my coordinator. Okay, she got it. Okay. Thank you, guys. You guys be safe and have a happy holidays.
You too. Thank you, Your Honor.
You too. You as well.
Bye-bye.
Bye-bye.
Oh, wait. There's someone else entering. There's someone else for this case?
There shouldn't be, Your Honor.
Okay. Mr. Raccoon or Runyon? Mr. Runyon, he's not on this case?
No, Your Honor.
Okay.
Thank
All right. You guys have a great day.
Okay.
Mr. Runyon, how are you?
Good. How about yourself, Your Honor?
Good, good. What are you here for today?
The 9:45. Do you need me to hop off and wait till then?
No, not at all. Let
Okay.
me just pull that up real quick and make sure we. Is Miss Dolly your opposing counsel?
It should. I think Josh Davis.
So I don't know who Miss Dolly is. So are you on the Kinnuan?
Correct.
And Miss Dolly, ma'am, what are you here for? You're muted, ma'am.
Yes, I'm here for Kinnuan.
Okay, great. And which side do you represent?
Defendants, the plaza at Richardson.
Do we have any other attorneys we're waiting for on this, or do we have all counsel present? It's still very early, so
yes.
We're good for plaintiff. I mean, if we have extra time, that'd probably be great if we can get started early, Your Honor. So
that's fine with defendants. Yes, that's fine with defendants, Your Honor.
And you're the only defense attorney on this one?
That's correct, sir.
Okay. All right. Well, fantastic. Let me just make sure I'm pulling up the correct thing here. Just want to make sure this is the correct motion.
That's it, Your Honor.
Okay. And I'm going to make sure I'm pulling up the correct order that you're requesting. Okay. If y'all don't mind, I really appreciate you doing that checklist order. I'm going to go ahead and print that out right now. I'm going to leave the screen for a few minutes because I have to go pick up the printout. So I will be back in the next minute or two. So just give me a second.
No problem.
Hi, counsel. This is the court reporter. Can I get counsel's name? I have Mr. Josh Davis, and who's the other counsel?
Sure, it's Diane Dawley, Dawley.
Okay. Diane, the regular spelling?
Yes, ma'am.
There you go. Thank you.
Thank you.
Okay, sorry for the delay there. I just want to let you know that we are about to go on YouTube. So are you guys ready to get started?
Yes, Your Honor.
Or are we already on? Wait a minute, what's going on here? Let's see.
We're already on YouTube.
Oh, we are. Never mind. Okay, let's go on the record on cause number 207232. Kathleen Kinnuin. How do you say that? Kinnuin? Oh, you're muted, Mr. Yeah.
Kinnunen.
Kinnunen versus the Plaza at Richardson LTC Partners, Inc., DBA The Plaza at Richardson. Counsel, make your appearances.
Jacob Runyon for the plaintiff.
Diane Dolly for defendants.
And we're starting a few minutes early, but that's based kind of on the representation that there are no other attorneys that we're expecting. So let's go ahead and get started. We got a very useful order on plaintiff's motion to compel. So let's just kind of hear some argument here. We'll start with the plaintiff.
Great. Thank you, Your Honor. Just kind of a preliminary issue, Your Honor. Yesterday, I filed an objection to Defendant's Exhibit C, which was attached to their response. Exhibit C contains various Chapter 74 expert reports from other cases. This is the same exhibit they attached to this exact same motion about a week and a half ago in another case in Judge Redmond's court. This is in violation of 74-351K, which states that the expert reports cannot be used for any other purpose, including another hearing. And so, Your Honor, just to get started, I would respectfully request this court strike their Exhibit C.
Ms. Dolly?
Your Honor, these are their expert reports on all of their cases they filed and we've represented. And so as that part of our exhibits is all cases that they have served us expert reports. We're using them for the purpose to show that they did not need policies and procedures with these specific expert reports prior to filing them.
All right, I'll go ahead and grant the motion to strike. Let's proceed.
Thank you, Your Honor. So, Your Honor, today, this case involves a nursing home. We allege various nursing home abuse, failure to sufficiently staff the facility. Contained within plaintiff's petition were discovery requests. There were 4 requests for production. Each one of those requests, as you can see in the reply and in the motion, are specifically keyed up to various regulations promulgated by the executive director. And there is one interrogatory which also requests the name of the director of nursing, the administrator. These are key individuals running the facility, staffing the facility. Your Honor, the deadline for plaintiff's Chapter 74 expert report runs on January 8th. So it is coming up here quickly. Each one of these requests is requesting documents which must be made publicly available. So something to keep in mind, today, Your Honor, any member of the public could walk into this skilled nursing facility and request access and gain access to these documents. So that's what they're withholding, are documents that, as now we're in litigation, I'm, prohibited from entering the facility and requesting these documents, but any member of the public could walk off the street and gain access to these. Now, this is very specific to nursing homes. It's only found in 242.404 that these documents, these policies and procedures must be made publicly available. 241, which governs hospitals, 247, 248, which govern, at-home health. They don't have this same, and nowhere else in the code does it request that facilities or some groups' policies and procedures must be made publicly available. And this is important as Your Honor could turn to 242.001. This is the scope and purpose of this chapter. And it says, this chapter and the rules and standards adopted under this chapter establish minimum acceptable levels of care. A violation of the minimum acceptable level of care established under this chapter or rule or standard adopted under this chapter is forbidden by law. So these policies and procedures, and it goes on stating how these are made public essentially to provide the public with information concerning the operation of these institutions. So, Your Honor, typically in other cases that I've had, defendants have at least filed objections. Here, defendants didn't even file any response at all. So under 193.2E, they've waived any objection, which makes even more today no substantial justification for their failure to produce these documents. So kind of the first question, even if they had have answered them, is one, whether discovery is permissible during the stay under 74-351S. Now, there are at least 4 courts of appeals that have all stated such. The Third Court of Appeals in Bogart, the Second Court of Appeals over in Fort Worth, in Baylor.
In Bogart? Where's Bogart?
The Third Court of Appeals, Your Honor.
In Beaumont or what's?
Oh, I'm sorry, Your Honor. Bogart is the party in the lawsuit.
Oh, okay.
Sorry, sorry for the.
What is the Third Court of Appeals? Is that Beaumont or where is that?
You know, I actually not sure where it's.
Okay, I'm just curious. You said Bogart. I'm like, I don't know where there is a Bogart.
Yeah, but just speaking of the Bogart case. Here's a quote from it. Appellees dismiss the significance of the limited written discovery that 74-351S nominally permits, asserting it is widely understood not to extend beyond the medical records specifically mentioned in that subsection, which on a keynote is exactly what defendants are stating here. And it goes on, and defense counsel in healthcare liability actions uniformly refuse any other written discovery. If that could be so, it is not because anything the legislature provided in 74-351S. And, you know, the Second Court of Appeals, exact same thing, 13th Court of Appeals, and more importantly, the Fifth Court of Appeals, Your Honor, in Ray Smith. This is a case that I'm representing plaintiff on. Louis Brisbois is on the other side of that case. And in that case, the Fifth Court of Appeals directly stated that, you read here, makes clear the exception covers more than just medical records or hospital records. And this is at page number 3. The exception merely requires that such information be related to the patient's health care. As there is no dispute, the relator's claims alleging inadequate supervision and services to meet a nursing home resident's health care needs and to protect her from harm are healthcare claims, it logically follows that training and staffing policies are integral components of nursing homes' rendition of healthcare services. And that quotes directly from the Supreme Court in DiversiCare. DiversiCare also was a nursing facility. There, that case dealt more with premises liability. They were trying to determine whether or not this case even fell under 74. And the Supreme Court pointed out, they pointed directly to these statutes in 242 and these other regulations. And it states on its page 850, DiversiCare's training and staffing policies and supervision and protection of Rubio and other residents are integral components of DiversiCare's rendition of healthcare services to Rubio. So, Your Honor, I think case law is quite clear that written discovery is permissible. Now, it's not, you cannot conduct depositions. Totally agree with that, but there is some written discovery under 192.7, 200, and 205 that is permissible, and certainly request for production of documents which are integral components to the rendition of healthcare should be found to be relevant, Your Honor. And just kind of for the sake of time, I won't go through each one of the regulations, but those regulations also include that language that they must be made publicly available. These are the nursing and staffing policies and procedures, the operating policies and procedures in there. Now, kind of jumping ahead, I know once again, defendants are going to rely, there's a case out in El Paso. It's the Simmons case, Your Honor. The Second Court of Appeals in Baylor disfavored that case. In Ray Smith, the Fifth Court of Appeals also disfavored that case. In Simmons, it should be noted that it is a hospital, so not a skilled nursing home. But in Simmons, the plaintiffs completely screwed things up, didn't even get an expert. They used a nurse. They waited until the day their expert report was due, filed a motion to compel and claimed, hey, we need these policies and procedures. The court goes through I think 1 or 2 pages just discussing the diligence of them even obtaining these. And the court stated they cited to a law review article, which the law review article did something that you should never do, state something and don't put an actual citation for it in there from the law review article. But that in Simmons, they basically state that, hey, these policies and procedures aren't relevant. But it's important to note at footnote 6 of the Simmons case states, our opinion should not be interpreted to say that the hospital's policies and procedures are never discoverable. Rather, we simply emphasize that the trial court, under all the facts and circumstances of this case, did not act without reference to the guiding rules and principles when it denied Simmons' motion to compel. So simply, I think, in my opinion, I think the court in Simmons basically said, hey, you can't wait till the last second. You weren't going to get over the line here anyways. We're not going to give them. But it should be noted that in Simmons, the defendants actually filed written objections, which, counsel here, again, didn't even, answer the discovery request and just are claiming, hey, we didn't have to answer anything and we're protected by 74-351S. So, Your Honor, I would respectfully request this court order the production of these policies and procedures, which are integral components to the rendition of healthcare. In addition, the names of the administrator, the director of nursing, and the medical director. These are key individuals which, knowing their identities, can aid our expert in reviewing the records to help show understaffing of the facility. And we request that the court order them to produce those names also. Thank you.
Ms. Dolly?
Good morning, Your Honor. I'll try not to repeat, but there's a lot of similarities to my arguments. This is a healthcare liability claim. It does arise out of the care for Mr. Knoonan at the plaza at Richardson. So therefore, I think we can all agree that this lawsuit is governed by Chapter 74 of the Texas Civil Practice and Remedies Code. Just a little background. They filed their petition, served us on August 21st. And as I'm sorry, how did you pronounce your name, Runyon?
Correct.
Okay. Mr. Runyon said with their petition, they served requests for production and 1 interrogatory. We filed our answer on September 10th. And so therefore, pursuant to the section 74.351, their report was due January 8th. We are going to argue, I'm arguing that their motion for discovery, their motion is premature. They have not served defendant with the Chapter 74 expert report as required by the Texas Civil Practice and Remedies Code. And so therefore, the reason we did not answer is because discovery is currently stayed pursuant to that same Texas Civil Practice and Remedies Code. According to that same section, 74.351, plaintiff is required after defendant files their answer to file their expert report within 120 days. So we filed our answer September the 10th. And even in defendant's motion, he says that his response, that our responses to his discovery was due October 12th. So now they file this emergency motion. Defendants say that it's an emergency. We filed our answer September 10th. Our response is due October 12th. We never heard from them October. We never heard from them in November. And then all of a sudden in December, the 9th, almost 30 days, less than 30 days, they say, oh, we have an emergency motion to compel, or they file their emergency motion to compel. They never conferred with us. Mr. Runyon did send an email to Mr. Davis, and he attached as an exhibit and said, are you going to, and you can look at it, Your Honor, it's attached as an exhibit to his motion. Are you going to respond to the request for production? And Mr. Davis said, we aren't required to because discovery is stayed. I'm not speaking specifically or reciting the exact language, but this is not their first emergency motion. He had more than 2 months to confer with us. And even in the email, Your Honor, Mr. Runyon did not say, would you like to confer? I'm going to be following up with a motion to compel. We had no idea that he would be following up with a motion to compel because he did not specifically or even point out that a motion to compel would be following. But now it's an emergency motion, and this is not his first emergency motion. This is something that he files, and it seems to me that it's disingenuous that he's trying to circumvent the deadline for the January 8th plaintiff's expert report. But beyond that, Your Honor, the plain language.
She raises a good point, Mr. Runyon. Why the delay?
Your Honor, as far as the delay, I think there was possibly, maybe a 30-day, delay in between when I realized that they had failed to actually serve discovery responses. Yet, I still filed it within 30 days. I mean, there's only a fairly small window. I would agree. It's only a few week window that I have when defendants fail to produce these documents and actually getting my motion on file.
A few weeks, Your Honor, our responses were due October 12th. I'll remind the court. We never heard from Mr. Runyon in October. We never heard from Mr. Runyon in November. So when he says a few weeks, this is not, we all have received motions to compel, and certainly an emergency is not, if you file the same emergency motion every time, less than 30 days, it seems to be, it just is interesting that this is now an emergency. But moving on, Your Honor, the plain language of the statute is that all discovery is stayed. And Mr. Runyon repeated the statute, but I will, if you would let me, 74.351S states, all discovery in a healthcare liability claim is stayed except for the acquisition by the claimant of information, including medical or hospital records or other documents or tangible things related to the patient's healthcare. Now, Mr. Runyon said, talked about Simmons, but I would like to just say that it's still good law. It was a case of first impression, and there's no subsequent history, Your Honor. It does hold that the healthcare providers' policies and procedures are not related to the healthcare and thus are not discoverable before plaintiff serves a Chapter 74 expert report. I guess the most important part is that it's not related to the patient's healthcare. Policies and procedures are generic, they're general. Yes, they set certain, we're not saying that we don't abide by them. We're saying that they are not related specifically or.
What were the facts of the Dallas Court of Appeals case that you guys have cited to? Did it involve policies and procedures, or what was exactly the facts of that?
It's the same thing here. They want us to produce policies and procedures, and it's the same emergency motion, Your Honor. They want us to produce.
No, I mean, there was a Court of Appeals decision he cited to out of the Dallas Court of Appeals. What were the facts of that case?
Your Honor, can I?
Yeah, go ahead.
Answer. Yes, Your Honor. That was a skilled nursing facility, Your Honor, and in that the patient, the resident was experiencing multiple falls with a fracture, and there was only in the facility for approximately 3 weeks. We alleged essentially the same claims here, understaffing. And in that case, Your Honor, we served the exact same discovery request as we did here. Although for here, we limited it down to just a 3 or 4 month time period. In Ray Smith, we asked for a time period of 5 years. The court overruled all of their objections, gave us the policies and procedures for that 5-year time period, requesting the same, essentially, document policies and procedures which the state mandates be made publicly available.
Okay, so let's kind of go through this order.
Your Honor, can I respectfully ask if I can just have a few more minutes?
Okay.
There's a few other points that I wanted to make.
Sure.
One of the points that Mr. Runyon starts out with is that the policies and procedures are to be made public under Texas Health and Safety Code 242.404B. And in our motion, that would be page 7. That Texas Health and Safety Code is in direct conflict with Section 74.351 of the Texas Civil Practices and Remedies Code. And under Texas Civil Practice and Remedies Code, Section 74.002.
How do you distinguish this Dallas Court of Appeals case?
Well, as you know, I believe it's similar in the fact, but
I mean, that's what I have to follow. So, I mean,
it's similar to background facts, but I don't believe that all of the issues are exactly the same.
So let's do this then. I mean, I have to follow the Dallas Court of Appeals. I do have a question about how you worded the order. It's a little confusing to me. So if I agree with you, Mr. Runyon, am I overruling it says overrule or sustain. Sometimes overruling means I'm overruling the objection, sometimes sustain, but it's not clear here are you asking me to check overrule or sustain?
It would certainly be overrule, although I guess there's technically no objections on file.
Oh.
But yes, I mean, it would be overrule.
Okay.
On there.
All right. It was just a little confusing to me. All right. So I'm going to overrule the objections then. So what about the name of the director of nursing administrator, and is that cited in the Court of Appeals opinion?
Your Honor, that is the one difference from In Ray Smith. We did not have those interrogatory requests. So those would be specific to this case.
All right, then I'm going to go ahead and sustain that objection then. And I'm not going to award any attorney's fees. I do think, Mr. Runyon, you should confer with the other side, and filing this as an emergency motion does kind of concern me, but I'm not going to award any attorney's fees.
Your Honor, if I might real quick, I just kind of clarify for the record, this is the exact same law firm on here. I had the same motion a week and a half ago in Judge Redmond's court and overruled all this. I sent this case to them and specifically stated, hey, in light of this, I believe we're entitled to these documents. They then proceeded to tell me, well, we filed a petition for writ of mandamus of the Supreme Court, so this is no longer good law. And stated, so, I'm not quite sure at what point, how much more conference I need to do with the same law firm. I apologize if there's more. I'd appreciate any, recommendations, but I'm not quite sure what else needs to be done for conference purposes.
I can send you an email that I get that says, would you like to confer? We will, otherwise we will plan to file a motion to compel. Never was there mention of a code motion to compel.
So when can you get the documents to him by?
Well, Your Honor, I can tell you that working with these nursing homes right now with the COVID, I'm having trouble getting their medical records from the facilities because of how busy they are with everything at the facilities. So 60 days.
Your Honor, our expert report is due on January 8th. So I would propose, one of a few of the following. Either one, if defense counsel will agree to an extension. Two, if they won't agree to an extension, that this court use its powers under the Supreme Court order. I think it's order number 29, extending all statute of limitations, and extend our expert deadline at least until February 1st to give us time to be able to, the purpose of getting these is so our expert can review them. And, if it's 60 days out, that won't help us out for our expert report. That's why this was an emergency motion.
So what day again, January 2nd, or what day did you want?
Well, our report is due on January 8th. So if we can get them at least a week beforehand, I guess
week before
the first,
what?
The week before our deadline, January 8th. So, I mean, that would fall on the 1st, I believe, which was a holiday and the weekend. So I would suppose either December 31st or January the 4th at the latest.
I'll do January 2nd at 5 o'clock. Okay, I'll go ahead and get this scanned in, and hopefully the order will be entered today. You guys be safe, okay?
Thank you, Your Honor.
Thank
Thank
you.
you, Your Honor.
Bye-bye.
Bye-bye.
Okay. Okay, let me kind of look at next thing on the docket. What are you guys here for?
Your Honor, have a scheduling conference.
Okay.
Your Honor, I'm here for an application for a writ of garnishment post-judgment.
Okay. Is that on the tax appraisal case? The scheduling conference, is that the Callan case?
Yes, Your Honor.
Okay. And are both sides here for that?
No, we submitted an agreed scheduling order, but I was thinking that Rhonda would set a trial date after we submitted it. But this morning she said that we need to agree on a trial date. So I know that the early December date next year is bad for the appraisal district. Otherwise, we're open for something in November or January.
Yeah. So what you're talking about, January 2022 then?
Right.
Okay. I'm just apologize. Give me 1 second. So you said January 2022. Is that what you requested?
Yes, Your Honor.
January 4th.
That's fine.
Okay, we'll go ahead and set it then. Anything else we need to chat about?
No, Your Honor. Thank you.
All right, you guys have a good day.
Thank you. You too. Merry Christmas.
Thanks. All right, and we have somebody here, you said on the garnishment, or both sides here on that?
No, Your Honor, just the garnishor. The judgment debtor was given notice of the domestication, but hasn't entered an appearance in the case. And the garnishee isn't being notified until after, or the garnishee is being notified by service of the writ. Once it's issued.
Mr. Moss, what are you here for?
The default judgment, Your Honor, in Santos et al. Versus Lopez and Fernandez.
Okay. Okay, let me just make sure I have all the correct cases. The garnishment is the Piper aircraft case, correct?
That's correct, Your Honor.
Did you provide me an order on, okay, there we go.
There's a proposed writ, yes, Your Honor.
Okay. All right, let me go ahead and share screen this real quick because I do have a question. There it is. So you're requesting a writ, and then, so how do you kind of, let's talk about this. Commanded to appear before said court at blank at 10 a.m. We're not doing live hearings typically. So kind of explain how you envision this would work.
Yes, Your Honor. That writ is taken directly from the rules which have the form.
Mm-hmm.
And generally what's filled in there is what would be a typical answer date. It's kind of outdated because I don't think the garnishment rules have been updated for a good long time. But I think we could phrase it and it would be acceptable if it were to say, you are hereby commanded to be and appear before said court and file an answer. And I think that would be sufficient. Or file an answer to the writ of garnishment.
So it's okay. Therefore, you're commanded to be and appear. So how did you want to change that? I guess let me do this. Let me print this out, and we can talk about how to change the language on that to make it a little clearer.
Certainly, Judge.
All right. So let's look at the language real quick of this. So it says, therefore you are commanded to be and appear before said court at blank. How did you prefer, or how did we want to change that?
My proposed language is commanded to file with the court a response to the writ of garnishment in said county at 10 a.m. on the Monday following. So after the words commanded to, file with the court a response to the writ of garnishment, and that replaces everything up from the word be up to blank.
Okay. All right, got it. I'll go ahead and get that scanned in and entered.
We will check the docket, Your Honor. Thank you for your time.
Thank you. Okay, Mr. Moss, you're here on a default judgment, is that right?
Yes, Your Honor.
Okay, let me go ahead and pull that up real quick.
And I'm looking, Your Honor, I don't think we have filed any orders. I do
You've not filed an
apologize.
order. Which case are you here on, Zavala or Stanton?
Santos.
Margie Santon?
Santos, Margie, yes, Your Honor. And then Luis Romero, and then there are some et als in there as well, some minors.
Okay, you do have a proposed order here. Let me see.
Okay, perfect. I will apologize to my paralegal for doubting that.
Let's just, we'll share screen the order real quick. Is this
Okay.
the order?
Yes, Your Honor.
Okay. All right. I don't know if you and I talked about this before. Do you have affidavits, medical records affidavits on this case?
Yes, Your Honor. We filed medical record affidavits and then some sworn statements from the adults as well, kind of proving up the records and their pain and suffering.
Okay, I'm going to go ahead and print this out so I can fill it out as we go through. So,
Yes, Your Honor.
and then just be ready to share screen any exhibits you want to use for this.
Okay.
All right, so I'll be right back. Okay, Tony, you ready?
Yes, Judge.
Let's go on the record on cause number DC209988, Margie Santos, Luis Ramiro individually and Luis Ramiro as next friend of AR and BR versus Juan Lopez and Norma Fernandez. Counsel, make your appearance.
Robert Moss, attorney for the plaintiffs.
All right, Ms. Neese, are you here for this hearing as well?
No, Your Honor, I'm here for another case.
Okay, thank you. Let's go ahead and proceed then.
Okay, Your Honor. So does Your Honor have the affidavits in front of him as well? I don't know how much I should be presenting to you in terms of proving anything up or what you have on your end, should I say?
I would just do a full prove up. I can try to find it in the file, but go ahead and do a full prove up.
Okay. So let's see here.
Mr. Moss, you may proceed.
Yes, sir. I'm sorry. My system is going really slow. I'm trying to pull up what I had. I do apologize, Your Honor. Okay. So typically, Your Honor, I would just hand over the affidavits. I don't, how should I should proceed? I have now in front of me, but for the
So those,
Zoom, I'm
have
not
those
sure
all
how to
been
go about it. It's
filed
my
with the
first
clerk?
Zoom. Yes, Your Honor.
Okay. So you can refer to the clerk's record, or you can, have you already emailed the court coordinator those?
Yes, Your Honor. Everything's been filed.
Do you have those, Tony?
I didn't know I needed to look, Judge. Do I need to stop and look real quickly?
Yeah, just check and make sure you have it.
This is the one day I didn't plug up I didn't log on to my other computer. Did he send them to me or did he send them to Rhonda?
Do you know if you sent them to Rhonda or to?
I'm not sure, Your Honor. I'd have to ask my paralegal. She probably, to be honest with you, she probably just filed them with the court, I think.
Okay.
Because I have the notices of filing affidavits here.
Why don't you do this? Just, I can look at them online. Just go ahead and introduce whatever medical records you want to introduce, any affidavits you want to introduce. And then after you're done, make sure that they're numbered, email them to Tony. And Tony, if you don't mind, just putting your email address in the chat.
Okay, Your Honor, yeah, that's fine. You want me to number each affidavit, each medical affidavit as its own exhibit, or just they're all just exhibit?
It's totally up to you. Just whatever's going to be cleanest.
Okay. Okay, Your Honor, so for Miss Margie Santos, Ms. Santos has, excuse me, Cano Health and Rehab Clinics, and that in the amount of $6,811. That is from we'll call that exhibit one. Let's just do, how about I'll do each person as their own exhibit. So Ms. Santos will just be exhibit one, and that will be her medical affidavits.
Perfect.
Okay.
And what are her total medical expenses?
Ms. Santos has $6,811 in Cairo for that one. For Cano, she has $950 at AM/PM medical centers. She has $917.65 at People First Pharmacy, and then for radiology, she has $617.05.
Well, it's
for a total of $9,200.
What's the total?
I'm sorry, Your Honor. $9,295.70.
Okay.
Mr. Romero has total medical costs in his, we'll call him exhibit number 2. He has AM, PM medical centers for $950, Cano Health and Rehab Clinics, PA at $6,821, and then Radiology Consultants of Texas at $675.25 for a total medical bills of $8,446.25.
And that's Luis
And then the
Romero.
minor, yes, Your Honor.
Okay.
Then
Go ahead.
April Romero is a minor. She has Cano Health and Rehab Clinics, PA at $395. And then the minor brain, yes, Your Honor. I'm sorry, Your Honor.
And is that AR?
Yes, Your Honor. That's the
And that's
minor AR.
395 total?
Yes, Your Honor.
Okay. And then BR,
And
the
then
minor?
The minor BR has the same number. Cano Health and Rehab Clinics for $395.
Okay. All right. What is your testimony for pain? Was there something else, Mr. Ramos?
No, Your Honor, I just to keep it clean, I was going to put, so Ms. Santos will be exhibit 1, Mr. Romero will be exhibit 2, and then I will include the minors, since he's doing it as the next friend of them, as him in exhibit 2, if that's okay with Your Honor.
Just as long as you make it clear to Tony exactly which are which exhibits.
Yes, Your Honor. Yes, Your Honor, I will.
So what evidence do you have of pain and suffering and physical impairment on each of these folks?
Okay, can I share the affidavits that they have to submit?
Sure.
Your Honor?
Let me go ahead and permit that. Go ahead.
All right. Give me 1 second, Your Honor. Okay, we will call this exhibit 3. And this is the sworn statement of Luis Romero.
Okay.
And this is just kind of Mr. Romero going through the accident, his medical bills, the reasonableness of them. And then what he thinks would be a fair amount in pain and suffering, which is so total would be $16,892.50.
He doesn't describe his injuries at all though, right?
Yes, I do see that now, Your Honor.
And this is for Mr. Romero. His medicals are 8,446. Yeah, 25. So what evidence do you have then of pain and suffering, past physical impairment, and future physical impairment for Mr. Romero?
It would just be the medical affidavit, then, Your Honor, the treatment. I mean, it's a soft tissue injury, so obviously we're not going to argue that he's got, $100,000 in futures or anything along those lines.
Do the medicals contain any discussion of his impairment?
The Cairo medical records do, Your Honor. I could pull those up real quick if you like.
Yeah, that'd be great.
Okay. All right. So Mr. Romero started treating the end of October 10/28/19, treated through the first of the year, January 8th, 2020. So about 3 months of treatment, which I think would speak to a certain amount of pain and suffering just right off the bat if you have to treat for 3 months. Let's see. Let me go to his, or the initial report. Cairo has it where sharp and aching pain, cervical, thorax, lumbar, left shoulder, and headaches on a scale of from 0 to 10. And this is the initial examination, Your Honor. Pain is at 8 out of 10. So you go into the Cairo and you're almost at as high as you can go right off the bat. So he's at an 8 out of 10. Activities makes the pain worse. Condition has affected daily activities such as he missed time from work. He has difficulty sleeping, and the pain is the same all day. So so Mr. Romero, the day he checks into the visits to Cairo on October 21st, that's his symptoms. So he has to treat for 3 months. So I think you could, like I said, we're not going to pretend like he needs surgery or anything like that, but 8 out of 10, he's got a pretty decent soft tissue injury here. He's missing work. It's impacting him all day. So I think according to the medical records, it's not like, and as I said, Mr. Romero's not asking for a ton of pain and suffering. So I think that's probably a fair amount relative to what he's telling the Cairo on his first day of treatment.
I'll give 5,000 for past pain and suffering and 3,000 for past physical impairment. So what about for Margie Santos?
All right, give me 1 second, Your Honor, and I will, I think her affidavit is going to be the same, Your Honor. So do you want me to just go into her medical as well then?
Okay.
All right, give me 1 second to just pull it up. Okay, so Ms. Santos starts treating on 10/21/19 as well. She treats to the first of the year, January 8th. So once again, about 3 months worth of treatment. If I go to her initial examination, Ms. Santos, same thing. Pain is cervical, lumbar, right elbow, and headaches. She's having pain that radiates from her cervical down to her thorax. On a scale of 0 to 10, she puts it at an 8 out of 10. Pain is constant, the same. To be fair, hers, she's not saying that she's missing work like Mr. Santos was, but she's got the pain level at the exact same level as he does as an 8 out of 10. So, soft tissue, but still 8 out of 10. She had to treat for 3 months. And like I said, she's not asking for a ton either. But I think an amount somewhere around Mr. Santos, or excuse me, Mr. Romero's number would be a fair and reasonable amount in pain and suffering.
All right, I'll do 5,000 for pain and suffering and 3,000 for physical impairment for her. What about for the kids?
And let me just pull them up real quick. Your Honor, for the children, I think they just had some initial consultations. I mean, obviously, the 395 Cairo bill, they didn't have a ton. So we think if you want to just give them, whatever Your Honor wanted to give them for pain and suffering, I think would be fair and reasonable. But I'm not going to pretend like their medical records are going to show these long periods of pain. They weren't in it.
I'll award $205 a piece for pain and suffering to do a total $600 on each of the kids.
Okay. Okay, Your Honor.
And then you have at the end, plaintiffs, it is therefore ordered, judge and decree that plaintiffs have and recover from the defendants in the sum of, so do you want the total amount for all all of them, I guess, there?
You could, Your Honor. Yes, yes, Your Honor.
So I think the total is $34,942. Does that sound right?
Yes, Your Honor.
Okay. Anything else, Mr. Moss?
No, Your Honor, that will be it.
We'll go ahead and try to get that scanned today, and you should be able to see it as soon as possible.
Thank you, Your Honor. May I be excused?
You may. Have a good day.
Thank you. Happy holidays.
Thanks. You too. This isn't good. Let me see. There we go. All right. Our next hearing, I believe, is. Look this up. Ms. Neese, what do you hear on Zavala or Handbrake?
Yes, sir. Zavala. Yes, Your Honor.
Okay, that's a default judgment.
It is, Your Honor. Apparently, our office has just received all the bills in, and we did file them, the bills and records this morning. If you would like, I can submit a different order. We're just proving up liquidated damages in this matter.
Okay.
And if it would be all right with Your Honor, I would like to submit an amended order, proposed order on this, listing out just the medical for both Mr. Faustino Zavala and Miss Maria Zavala. And then with just very basic attorneys, court cost, excuse me, Your Honor.
Okay, so I'm kind of looking at this. It looks like we did a default judgment as to liability.
Yes.
And then you filed a default judgment on today, it looks like. No. Okay, sorry, let me look at this. Have you filed, did you file the motion for default judgment on the 25th? Is that it?
Yes, Your Honor, that would have been the one November 25th. And I believe, excuse me, on the 30th of November, it was granted as to liability, but then today was supposed to be on damages. But it's my understanding that the bills and records have just been filed with affidavits this morning.
Okay. And you said you filed those with the clerk, or did you email the coordinator, or what did you say?
The clerk, and it was another individual in our office, or medical records clerk, filed it with your clerk's office. Yes, Your Honor. But it was probably about 9 something when that was done.
Okay. So go ahead and email Rhonda, my court coordinator, and my court reporter, Tony.
Okay.
And then did you submit an order as well on this?
We did, Your Honor, but I think it needs to be amended. So it lists out how much Mr. Zavala and Miss Zavala's medical records, and then the court cost, and I can put those in the blanks there.
Okay.
I have not submitted that yet. I wanted to discuss it with you to see whether you would be fine with that. But I can do that today, certainly.
Okay. Sounds good.
Okay.
me see the.
I was just getting the email addresses down, Your Honor. Sorry about
Okay.
that.
All right. Are you ready to go on the record?
Yes.
Let's go on the record on cause number DC 206648, Zavala v. Garden. Counsel, make your appearance.
Heather V. Banahan Neese on behalf of the plaintiffs, Faustina Zavala and Maria Zavala.
And you've indicated that you've filed medical records and bills related to both of those plaintiffs. Is that correct?
That's correct, Your Honor.
All right. And then and you're just asking for medical bills in this. You're not asking for pain and suffering.
That's correct, Your Honor. And we're just asking for court cost, which is a little over $400, just for the filing of the lawsuit along with service of process.
Okay.
And I'll get you an amended order.
So you'll submit in the order the total amount of the medicals as well as, and I'll cross-check that against what you file. So just try to get that to me. Go ahead and email that to Rhonda as well as e-filing the order. And Rhonda, if you could print that out and put that with my other orders, but I'll be in tomorrow to sign those.
Thank you, Your Honor.
Thank you. Thank you, Ms. Neese.
All right. Have happy holidays and take care. May I be excused?
You may.
Thank you.
Have a good day.
You too. Bye-bye.
Happy holidays.